pass now the stage to Dr. Adam Abukari, which you can see here. He's an assistant professor in law at the Center of Financial Corporate Integrity at Coventry University. His research interest includes financial crime, artificial intelligence, and he's currently working on TRACE project to track illicit money flow. So thank you, Adam. The stage is yours. I don't know if you can eventually share. Yes, we can see your presentation. I don't know if you can make it full screen for the benefit of every one of us. Perfect. Thank you. Okay, brilliant. Thank you. You can unmute yourself and you can start the presentation.
Okay, thank you very much all for coming, and thank you for inviting me, Donato, Constantino, and then Alicia. It's been great to be here. My topic for today is looking at the challenges of regulatory framework on anti-money laundering software market in the EU. When I was invited to this conference, I looked at so many options because I'm actually working, as Alicia said, on TRACE project that deals with how to be able to develop artificial intelligence tools to track illicit money flows, including money laundering. But I thought that with the development of AI technologies and many that are coming up, it is important not only to look at the development, but also to look at the market. So I came out to look at this topic and to see how we can explore this area of research to harness knowledge. Okay, so the presentation is going to take 4 forms, 4 areas: introduction, challenges, prospects, and conclusion. As you may well know, the growth of anti-money laundering software market is really high. It's big enough for us to appreciate. It is in the region of $3.1 billion. In fact, that was estimated in 2022. And then the software market of anti-money laundering is diverse, not only on premises, on cloud, but also on applications and programming. At the same time, whilst this market grows, that the software market grows in big size and diversity, regulatory playbook and aspects that have to do with law, really, have been in the sense that because EU has a legal framework that captures 27 nations, various nations in this sub-region also have their regulations. They develop the software market regulations to be able to see how they can counter money laundering. However, because of diversity in these legal frameworks in the 27 EU nations, there's always the opportunity for regulatory arbitrage. That is, there's the opportunity for loopholes to be exploited by criminals in the software market. At the same time, because of the increasing growth of the anti-money laundering market, software market, and then the diversity that comes with it, it does appear that the laws that we currently have do not cover the growing size and diversity of the market. Because of this opposite direction between the law and then the growth of size of the market in some shape or form, it is important to look at the challenges that confront this market, and then the regulations that we have, including the MiCA, that is the current cryptocurrency regulation that was formulated and is being put forward, front-loaded, and then at the same time, the anti-money laundering regulations and the directives, from the 4th directive to the 5th directive currently, in particular, the anti-money laundering directive number 5. At the same time, if you look at the artificial intelligence regulation that is coming up, it was recently adopted by the European Parliament and is put forward to the European EU Council. It is important to note that all these legal instruments do have, even though they are covering a lot of issues that have to do with algorithms and then how the applications have to work, and in fact, even the growth of the market. But it is not enough to say that the algorithms that are being developed can be covered by all the legal instruments that we have currently in the European Union. So these are the challenges that, there are so many challenges, of course, but these are just few challenges that I want to explore with you today and to see how we can take it further in the research world. The first one is the fragmented measures or efforts by the law enforcement agencies and then law enforcement agencies and Parliament and the other authorities that formulate laws and regulations to be able to counter money laundering. These are fragmented in the sense that, as I intimated earlier, the national laws do not really catch up with the laws that EU normally comes up with. The transposition normally becomes challenging for a number of jurisdictions. The anti-money laundering regulations, of course, that's automatically transposed into EU law and national law, but for the directives, it's always been challenging for national jurisdictions to implement such directives. And so, because of that, there's been a challenge in implementing some of the essential rules that come up at the EU level. And as a result, it is always difficult to be able to regulate the anti-money laundering software market with this kind of fragmented legal framework. At the same time, you know, because of the advancement of money laundering techniques, you know, as new technologies develop, and then there's the difficulty of ensuring that new technologies comply or are compatible with the current softwares that we have, it becomes even difficult for law enforcement agencies to be able to frontally deal with the anti-money launderers, in the sense that the anti-money launderers, the money launderers actually are developing techniques, sophisticated techniques to go ahead of the scheme. They are able to develop technologies or that make the current new technologies that we have ineffective. So it is important to look at how the software that are being developed, to look at them carefully and to see how the loopholes can be addressed. At the same time, because of the divergences in the legal framework between the EU legal framework and then the national legal framework, it is difficult to be able to uniformly regulate the anti-money laundering software market. So another challenge that we need to look at is the complexity of anti-money laundering software market. You know, it ties to the competition between criminals being sophisticated ahead of the current measures or efforts to fight money laundering. The software market has various components, you know, on the premises, on cloud, you know, application programming, and so on. Because of these diverse components of the anti-money laundering software market, it is always difficult for regulatory framework to be able to catch up with the complexity of the software market. At the same time, you know, complexity of the complexity and changing regulations that we have. So now we have the fifth anti-money laundering directive. In fact, we do have another one which is not supposed to be called the sixth anti-money laundering directive, but it acts as the in some way, shape, or form, which deals with the criminal component, who delves much more into the criminal component of anti-money laundering, you know. But even though these changes happen, they are not able to, that is the rules and regulations or the laws do not catch up with the complexity of the market on this side of the divide, and then how regulations should be shaped to be able to match up with the software anti-money laundering market. So we do have technological limitations as well. What are the technological limitations? You know, because of the algorithms used in the market, that is the anti-money laundering market, has been in such a way that there are times that you have software that come out with false negatives and then false positives, you know. So these limitations really do not harness the efforts to counter money laundering, you know. And as a result, this is a regulatory challenge that needs to be looked at. At the same time, there is always increasing degree of data analytics. Data analytics, you know, basically deals with how big data in particular can be pulled up and then analyzed and presented for functional use and to be able to address specific needs. Because of this increase in the focus of data analytics, it is sometimes thought that this is just enough to be able to address money laundering, you know, but that is not the case. And this presents itself as a challenge. There's also high cost of compliance, you know, that's obvious. At the same time, there's concerns. This is very important. There's concerns about data privacy and security, in the sense that, I mean, as previous speakers have highlighted, privacy and security issues have become a major concern because, I mean, even though we want to give opportunity to developers to go out there to find solutions to be able to confront money launderers, but it's important to also respect the rights of fundamental rights of the people. Even though, I mean, they may be criminals, it doesn't matter who they are, it's important to protect their rights. But even though it's important to protect their rights, how do we balance this importance to protect their privacy and security rights and that of the need to develop new technologies, advanced technologies for that matter, to be able to confront money laundering? There are a few prospects that I thought we could talk about this evening, one of which is increasing demand for anti-money laundering software. Many companies, I mean, even though we can just say that money laundering efforts have not really yielded the kind of benefits that we would have wanted from it. You know, many companies have been able to come up with different software solutions to confront money laundering, you know, for reputational issues, and then at the same time to comply with the law. So because of this increasing demand for anti-money laundering software, the market has the potential to grow. At the same time, regulatory framework has the potential to look at this growth and to be able to see how the different rules can be developed to counter any crime that these software are developed to confront. This important thing about risk-based approach. Risk-based approach is cardinal in the new proposed, of course, Artificial Intelligence Act by the EU. You know, that is to say that every effort has to be tailored towards specific risks in order to be able to in order to confront money laundering. And this is an opportunity. If companies that are developing software to counter money laundering really look at this risk-based approach to develop their technologies, it may well be possible for them to fall in line, not just within the law, but also to see how they can be able to match up with the increasing complexity of the criminals that also continue to develop technical solutions to enhance their criminal conduct. At the same time, there is a need for specialized software for different industries in the anti-money laundering market. You know, this need for specialized software in different companies and departments is really an opportunity and a prospect that can be explored. I would then conclude by saying that even though the anti-money laundering software market is growing and has a number of challenges, you know, there are a number of factors that we should consider when we are confronting money laundering. One of the factors is to ensure that we look at the risk-based approach in harnessing our efforts to counter money laundering. At the same time, we need to look at the nuances between the regulatory framework and then the sophistications of money launderers, you know, and see how we can be able to catch up with them in time. Thank you very much for giving me this opportunity. Any questions?
We will have time for the Q&A session a little bit later. In the meantime, thank you very much for your overview of the challenges and prospects of AML. It was a very systematic analysis of what we have to explore much more even in the panel session later. Okay, so thank you very much, and I'm going now.